Welcome to Wealthfinity. Today, we're going to talk about a topic: debt collectors calling you at work. You may be surprised to learn that debt collectors do have the right to contact you at your place of work, but there are limits to what they can do and say. In this video, we'll discuss your rights as a consumer and provide tips on how to handle debt collectors if they do call you at work. Get ready to learn the shocking truth about debt collection calls at work, right here on Wealthfinity. Debt collectors are known for being persistent in their efforts to collect outstanding debts, but they are also subject to certain rules and regulations regarding when and how they can contact you. One common question that many people have is whether or not debt collectors can contact them at work. Debt collectors can be a source of stress and frustration for many individuals, and receiving calls at work can add an extra layer of discomfort. According to the Fair Debt Collection Practices Act, FDCPA, debt collectors are prohibited from contacting you at inconvenient times or places, such as before 8 a.m. or after 9 p.m., unless you have agreed to it. They also cannot contact you at work if they know or have reason to know that your employer prohibits such calls. If a collector continues to call you at work after you've informed them that your employer doesn't permit it, they may be in violation of the FDCPA. For example, in California, debt collectors are not allowed to contact you at your place of employment if they know or should know that your employer prohibits such calls. In addition to the FDCPA, many states also have their own laws that prohibit debt collectors from contacting you at work. If you're receiving calls from debt collectors at work, it's important to keep a record of the calls. This includes the date and time of the call, the name of the collector, and the company they represent. If you inform a debt collector that you are not allowed to receive calls at work, they are required to stop calling you there. You can do this verbally or in writing. It's important to keep in mind that the debt collector can still contact you at other times and places, such as by mail or email. To stop calls from collectors at work, you can send a letter to the collector requesting that they stop contacting you at your place of employment. This letter, known as a cease and desist letter, should be sent via certified mail and should include a copy of your employer's policy against such calls. Additionally, debt collectors cannot harass or threaten you at work. They are not allowed to use profanity, make repeated calls, or threaten to take legal action if they do not intend to follow through. If a debt collector is violating these rules, you can file a complaint with the Consumer Financial Protection Bureau. Another option is to hire a consumer attorney who can help you navigate the legal system and protect your rights. An attorney can also help you negotiate with collectors and come up with a payment plan that works for you. Additionally, debt collectors are prohibited from contacting you at work if your employer has a policy against such contacts or if you inform the collector that your employer prohibits such contacts. If a debt collector contacts you at work despite your request or your employer's policy, they may be in violation of the FDCPA and can be subject to penalties. It is important to note that debt collectors are allowed to contact your employer in order to obtain information about your employment status or contact information, but they are not allowed to disclose the nature of the debt or that they are debt collectors. If you have any doubts or concerns regarding the actions of a debt collector, you should consult with an attorney or contact the Consumer Financial Protection Bureau, CFPB, for assistance. Another thing to keep in mind is that debt collectors can't contact you before 8 a.m. or after 9 p.m. local time. They also cannot contact you on Sunday. It's also important to remember that the FDCPA applies only to third-party debt collectors, not to the original creditor or the company to whom you owe the debt. It's important to keep in mind that being in debt can be a stressful experience, and it is essential to know your rights and the limits of the actions that debt collectors can take. By understanding your rights and the rules that debt collectors must follow, you can better protect yourself and your finances. Debt collectors are allowed to contact you at work, but they must follow certain rules and limitations set by the FDCPA. If you inform them that you are not allowed to receive calls at work, they are required to stop calling you there. However, they may still contact you at other times and places. If a debt collector is harassing or threatening you at work, You can file a complaint with the Consumer Financial Protection Bureau. Receiving calls from debt collectors at work can be a stressful and uncomfortable experience. However, you do have rights under the FDCPA and state laws, and there are steps you can take to protect yourself. By keeping a record of the calls, sending a cease and desist letter, and consulting with an attorney, you can take control of the situation and work towards resolving your debt. In conclusion, the video, The Shocking Truth About Can Debt Collectors Call You at Work, highlights the legal rights of debt collectors and consumers in regards to workplace communication. It is important for individuals to understand that while debt collectors may contact them at work, they cannot harass or threaten them or their employer. Consumers also have the right to request that debt collectors stop contacting them at work. It is recommended to speak with an attorney or financial advisor if you have any questions or concerns about debt collection laws.